Ladies and gentlemen, there have been several reports of raids conducted by U.S. Immigration and Customs Enforcement agents in Arizona, and these reports contain some very concerning allegations. However, the more I looked into them, the weirder they became, to the point where Immigration and Customs Enforcement, or ICE, is either making some potentially unprecedented errors, or the reports of ICE activity are maybe inaccurate, or I'm just wrong. I'll let you decide after I present my evidence. But before I do, please keep in mind this should be considered my personal opinion based on my own training and experience, as well as the information being cited. Nothing in this video should be considered legal advice. That being said, the reports appear to allege that ICE agents have been detaining people for hours in Arizona under the suspicion that they may be illegal aliens, only to discover the people being detained are American citizens belonging to Native American tribes. Not only is that a bit awkward for the ICE agents, it might also violate 18 U.S.C. 242, which covers, among other things, deprivation of constitutional rights by someone wielding law enforcement authority. What kind of rights might be deprived here? Well, the constitutional right to be free from unreasonable seizure, guaranteed by the Fourth Amendment, springs immediately to mind. In Arizona, per Arizona Revised Statute, or ARS 28-1594, a peace officer may stop and detain a person as is reasonably necessary to investigate an actual or suspected violation. Not only that, under ARS 13-2412, it is unlawful for a person, after being advised that the person's refusal to answer is unlawful, to fail or refuse to state the person's true full name on request of a peace officer who has lawfully detained the person based on reasonable suspicion that the person has committed, is committing, or is about to commit a crime. A person detained under this section shall state the person's true full name, but shall not be compelled to answer any other inquiry of a peace officer. But what determines reasonable suspicion? In the 2020 case State v. Jarrett, the Arizona Court of Appeals wrote, quote, "A police officer is permitted to conduct a brief investigatory stop when the officer has a reasonable articulable suspicion that criminal activity is afoot. By definition, reasonable suspicion is something short of probable cause. Although reasonable suspicion is more than a hunch, it only requires that an officer articulate some minimal objective justification for an investigatory detention. To determine reasonable suspicion, a court must look at all relevant factors, each of which could have a potentially innocent explanation, and examine them collectively. We afford deference to a law enforcement officer's ability to distinguish between innocent and suspicious actions. The actual reports of Native Americans being detained don't yet contain enough information to establish what the reasonable suspicion was, but we can create a hypothetical that might meet the burden of reasonable suspicion in this case, but should not be considered the actual series of events. Perhaps one or more people filed reports that made their way to ICE that they were in a restaurant and they overheard employees saying that they were surprised the employer was hiring people that were known to be illegal immigrants. ICE agents might even get a meal at that restaurant and ask a few questions to the wait staff to see if they could elicit these comments themselves without revealing their identity as agents. It is possible to do this in a perfectly legal manner. Now, let's assume that while eating their meal, they also overheard or were told that employees were illegal immigrants. Maybe they initiated a Form I-9 inspection, which requires an employer to produce I-9 forms related to employment eligibility. Perhaps they discovered certain employees had not provided the employer with documents establishing employment eligibility or had provided false documents. It could be argued that at that point, they would have reasonable suspicion. But so far, we've only addressed what Arizona peace officers have the authority to do. Are ICE agents considered peace officers in Arizona? Do they have the authority to detain people? Can they lawfully order you to provide your name under threat of prosecution if you're merely detained? Arizona defines peace officers as sheriffs of counties, constables, marshals, policemen of cities and towns, commissioned personnel of the Department of Public Safety, etc., etc. They had to be certified by the state of Arizona, more or less. I don't believe ICE agents inherently are certified by the state of Arizona, but the Arizona Department of Public Safety entered into an agreement with ICE to be trained and certified to enforce immigration law. This agreement was made in 2007, and it is in place until either party decides to end it. The Phoenix Police Department did the same thing. So if these agreements were still in place, then law enforcement in the area that the reports have been made could, in theory, absolutely have the federal authority to enforce immigration law and the state authority to act as peace officers. But when I was checking whether or not these agreements were still in place, I found this map, which indicates they aren't. And this list from ICE's own website suggests the only peace officer agency in Arizona with the authority to enforce federal immigration law is this one. This raises an interesting question. Do we now assume only ICE agents could operate in Maricopa County, where the reports seem to be coming from, or would La Paz Sheriff's deputies have the authority to leave La Paz County, enter Maricopa County, and enforce federal immigration law there? Well, per ARS 11-441, the sheriff may assist in executing the duties prescribed in this section in another county at the request of that county's sheriff. But 8 U.S.C. 1357, the same statute that provides the authorization for trained local law enforcement to act as immigration officers, states, quote, "Any officer or employee of the service authorized under regulation prescribed by the Attorney General shall have power, without warrant, to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States," end quote. Traditionally, an interrogation inherently refers to a person who is being asked questions and is detained. So there are situations under both state and federal law where a La Paz sheriff's deputy operating in Maricopa County has the authority to detain individuals and lawfully order them to identify themselves. ICE agents have the authority to detain individuals in Maricopa County, but I don't believe that they have the authority to order someone to provide their name if merely detained, in Arizona at least. So a failure to identify should, in theory, not extend the detention if the law enforcement personnel are ICE agents and only ICE agents. So knowing what police agency you're dealing with might be incredibly important. Let's assume the law enforcement personnel are only ICE agents. We know they have the authority to detain and interrogate, but do they have the authority to enter employee-only areas to do so? Yes, if they have a warrant signed by a judge, or permission by the employer, or someone authorized to provide that permission, or if the subject tries to flee and create an exigent circumstance. There have been concerns ICE agents aren't presenting warrants, but that doesn't necessarily mean they need one or that they don't have one. However, if they are merely entering areas of a business that are open to the public, they don't need a warrant or permission or exigent circumstances. While in those areas, they can ask questions about immigration status as long as the person is free to leave, and they may briefly detain a person if they have reasonable suspicion that the person is an illegal alien. Generally, you don't have to answer their questions, but do keep in mind that while declining to answer a question rarely establishes reasonable suspicion, that's not always the case. For example, the 2013 Supreme Court case Salinas v. Texas discusses a situation in which a man was voluntarily answering questions while not detained, but fell silent when he was asked if his shotgun would be matched to casings found at a murder scene. This silence was used as evidence against him in court, and the Supreme Court ruled silence is not the same as invoking your Fifth Amendment right to be free from self-incrimination. If you would like to invoke your Fifth Amendment rights, it may be in your best interest to let law enforcement know verbally, or perhaps by presenting a written document saying you wish to invoke your Fifth Amendment right. Also, if you're not detained, you might not be able to invoke your Fifth Amendment rights because if you're not detained, there may be nothing to invoke because they don't apply until you're in police custody and not free to leave. But speaking of documents, what if you don't provide identifying documents to ICE agents? American citizens aren't required to carry them, and in the 1983 case Gonzalez v. Peoria, the U.S. Court of Appeals for the Ninth Circuit wrote, "The inability to produce documentation does not in itself provide probable cause." So if people are in fact being detained under mere reasonable suspicion for hours, and if the reports are true that ICE doesn't recognize state IDs or certificates of Indian blood, that doesn't make sense. Because in theory, absent additional relevant information, by that time, the detention would become a de facto arrest, which requires probable cause, which is not established merely by the inability to produce recognized documents. So, if this actually happened, I suspect it was either a violation of someone's rights or probable cause had been established by something else. Perhaps probable cause had been established for a violation of 8 U.S.C. 1324, which makes it a felony to hire 10 or more people in a 12-month period with the knowledge that these people are illegal aliens, but this would only apply to the employer, not the staff of a business. So unless the detained American citizens were the employers or ICE was trying to determine what person at the job site was the employer, I don't believe this would apply. Perhaps employees who know their coworkers are illegal aliens are violating ARS 13-2929, which makes it illegal to conceal, harbor, or shield, or attempt to conceal, harbor, or shield an alien from detection in any place in this state, including any building or any means of transportation, if the person knows or recklessly disregards the fact that the alien has come to, has entered, or remains in the United States in violation of law. But this appears to only apply if the person concealing, harboring, or shielding the alien is also committing a separate criminal offense. Now, you might be tempted to suggest this also violates federal law, and so the act is inherently criminal without needing any other crime, but the federal equivalent of this statute, 8 U.S.C. 1324, only makes it a crime if the harboring, concealment, or shielding is done specifically to prevent the illegal alien's detection. Do keep in mind, if you're planning on shouting a code phrase to alert employees that ICE is coming, they watch TikTok too. Make informed decisions. But even if people aren't violating ARS 13-2929, its source, Arizona Senate Bill 1070, is relevant. The bill was passed in 2010, but severely limited by the Supreme Court in 2012. However, this section remains. For any lawful contact made by a law enforcement official or agency of this state, or a county, city, town, or other political subdivision of this state, where reasonable suspicion exists that the person is an alien who is unlawfully present in the United States, a reasonable attempt shall be made when practicable, practicable, to determine the immigration status of the person. The person's immigration status shall be verified with the federal government pursuant to 8 United States Code Section 1373C. And in regards to this section, the Supreme Court wrote, if the law only requires state officers to conduct a status check during the course of an authorized lawful detention or after a detainee has been released, the provision would likely survive preemption. This brings us back to the detention of American citizens and the verification of their citizenship status. If a detention has occurred, Arizona law enforcement can conduct a check of the subject's citizenship status. They can conduct a check even after the detention has ended. They cannot unreasonably extend the length of the detention to conduct this check. And someone who is detained by an Arizona peace officer is presumed to be a citizen if they are able to present a valid Arizona driver's license, a valid Arizona non-operating identification license, a valid tribal enrollment card or other form of tribal identification, or any valid United States federal, state, or local government issued identification. But ICE agents, to the best of my knowledge, are not inherently considered peace officers in Arizona. The documents they recognize, at least for the purposes of employment authorization, are a United States passport, an alien registration receipt card or permanent resident card, a foreign passport that contains a temporary I-551 stamp or temporary I-551 printed notation on a machine-readable immigrant visa, Form I-94 or I-94A as applicable, an employment authorization document which contains a photograph, Form I-766, or a military identification card which may only be accepted by the armed forces. For identification purposes, not employment authorization, ICE recognizes the following documents. If you're under 18, a school record or report card, clinic, doctor, or hospital record, or a daycare or nursery school record. If you're over 16, a driver's license or identification card containing a photograph issued by a state, school identification card with a photograph, voter's registration card, U.S. military card or draft record, identification card issued by federal, state, or local government agencies or entities, military dependents identification card, Native American tribal documents, United States Coast Guard Merchant's Mariner card, or a driver's license issued by a Canadian government authority. It's important to note that an identifying document may not be the same as a citizenship document. However, presenting any of these documents should, in theory, enable ICE to check whatever database they might use to confirm you are a citizen. But, as a reminder, again, American citizens aren't required to carry these identification cards, so even if you don't have them on you, the detention can still only last a reasonable amount of time. And this brings us back to the question of how long is a brief or reasonable amount of time? And the answer is, it really depends. For example, per ARS 13-3905, a person can be detained for up to 3 hours for the purpose of taking evidence in the investigation of a felony. Or, on the other hand, in 2011, the Arizona Supreme Court determined in State versus Boteo Flores that a subject's detention as part of an investigation into a felony became a de facto arrest after he had been in handcuffs for 30 minutes, which, without the establishment of probable cause, presumably violated the subject's right to be free from unreasonable seizure under the Fourth Amendment. So, let's summarize what we've learned. ICE agents may have all the authority of peace officers in Arizona. There are several circumstances allowing ICE agents or peace officers to enter a place of business and ask questions. There are rare circumstances where silence may be used as evidence that might, at the very least, establish reasonable suspicion. If reasonable suspicion is established, ICE agents or peace officers likely have the authority to briefly detain someone. Once lawfully detained, peace officers can require the subject to provide their name in Arizona, but this might not apply to ICE agents that are not also considered peace officers in Arizona. As long as the length of the detention is not unreasonable, these agents or peace officers can check your citizenship status. The length of time a detention is reasonable depends on the situation. 3 hours may be reasonable, 30 minutes may be unreasonable. It depends. ICE recognizes, among other things, state or federal IDs and tribal documents as identifying documents. This does not mean ICE recognizes them as evidence of citizenship. Arizona peace officers do recognize state or federal IDs and tribal documents as evidence of citizenship. This is a lot of information, but the facts right now are pretty scarce. Do we have evidence that crime might have occurred? Yes. Deprivation of rights. Do we have a suspect? Yes. ICE. Do we have enough to build a strong case? No, we actually don't. But that doesn't mean a strong case can't be built. We just need to identify what aspects of the existing reports need to be focused on to get more information. But how? Well, one of my preferred methods as a criminal investigator was to start by assuming every piece of information that does not directly contradict another piece of information is true, but may be presented, intentionally or otherwise, in a way that distorts the reality of the situation. If I remove any uncertain context and rely only on the remaining facts, I can then identify the areas where different contexts could change the situation entirely. What context makes a suspect innocent, and what context makes them guilty? I need to focus my attention on figuring out which context it is because, as I quoted earlier, quote, a court must look at all relevant factors, each of which could have a potentially innocent explanation, end quote. I need to be able to prove the explanation is not the innocent one for a conviction to be made. I'll give you some examples of what context I would need to determine ICE had violated the constitutional rights of American citizens using quotes from articles I've read about this situation. I will be assuming all information is true, despite statements in the articles suggesting there are no verified detentions. On Thursday, Navajo tribal leaders reported that they have received calls and text messages from Navajo people living in urban areas who have been stopped, questioned, or detained by ICE. Those reports sparked outrage among Navajo Nation Council members and prompted a detailed discussion of the topic during a Nabik Iyati committee meeting. Okay, the relevant presented facts are Navajo people are reporting being stopped, questioned, or detained by ICE. Immigration officers can question anybody in public if those people aren't detained. Detaining someone would require reasonable suspicion, which generally can't be based merely on an individual's skin color or spoken language, but there are circumstances where it could. Stopping a vehicle within 100 miles of the border is within the authority of immigration officers. So the context I need is what was the nature of each individual immigration officer contact, what was the location of each individual immigration officer contact, and what information prompted each individual immigration officer contact. This does not inherently establish a violation of rights, but I feel it's certainly worth looking into. Atatli reported to the council that she received a call about a case involving a Navajo citizen who was detained for 9 hours. She did not share the individual's identity. Atatli told council members that there is a need for emergency protocols because many tribal members already struggle with access to proper documentation, which can get worse under the ICE sweeps. If the detention lasted 9 hours, I don't believe it would be lawful, unless probable cause exists, which has a greater burden of evidence than reasonable suspicion. Of everything that has been reported, this is the most concerning to me, and I very much want to know what the specific reason for the detention was. There are circumstances where this could be legally justifiable, but there are certainly circumstances where it wouldn't be. From personal experience, I know people sometimes misunderstand whether they are detained based on reasonable suspicion or based on probable cause and what the actual reason for the detention was. All of it, needs to be checked. Despite possessing certificates of Indian blood, CIBs, and state-issued IDs, several individuals have been detained or questioned by ICE agents who do not recognize these documents as valid proof of citizenship, the Navajo Nation Council stated in a press release. The relevant presented facts are that individuals have been detained by ICE, individuals have been questioned by ICE, and ICE agents do not recognize certificates of Indian blood as proof of citizenship. Nothing here actually establishes a violation of rights yet. ICE can detain people if there is at least reasonable suspicion, so we would want to check what that reasonable suspicion was for people who were detained. ICE can question people without detaining them, so that's not necessarily relevant. ICE does not recognize tribal documents as proof of citizenship, at least not when it comes to employment eligibility, but they do recognize them as identifying documents. This does not establish ICE has violated anyone's rights. Arizona peace officers, on the other hand, do recognize those certificates as proof of citizenship. Or, we assume that those are Native American tribal documents, which I would argue yes. This means it is incredibly relevant whether these are actual ICE agents or if they are authorized peace officers. If they were the latter, I suspect a failure to recognize these documents as citizenship documents would be a violation. If they were ICE, the detention would have to be unreasonably long before the presentation of the documents or unreasonably long after the presentation of documents. So not only do I now need to check the reason for the detention, I need to check who actually conducted the detention, how long the detention lasted before documentation was provided, and how long it lasted after the documentation was provided. The woman says she was at her worksite in Scottsdale, Arizona, when she and 7 other indigenous citizens were lined up behind white vans and questioned for 2 hours without their cell phones or a way to contact their families, according to Hatathli. Now, is it ICE or some other entity? I don't know, said Hatathli, who represents Legislative District 6, which encompasses the Navajo Nation. The woman says she was eventually permitted to use her cell phone and text family members who sent her a photo of her certificate of degree of Indian blood, CDIB, and she was then allowed to leave, Hatathli said. It is unclear what happened to the 7 other indigenous people who were questioned. The presented facts are 8 Native Americans were at work. They were moved to a location and questioned for 2 hours. They did not have their cell phones. It was unclear if the people conducting the questioning were ICE agents. A woman was allowed to leave after presenting a photo of her certificate of degree of Indian blood. We don't have confirmation that it was ICE, and we know the type of law enforcement agency is relevant, so that needs to be investigated. We also don't know if the workers didn't have their phones on them when contact was made, or if the workers had their phones confiscated after contact was made. This is important too, because confiscating a phone is a seizure under the 4th Amendment and must be reasonable. Before we can determine if it was reasonable, we need to determine if it was seized. We also need to know if she offered to provide the documents using her phone and was denied the opportunity. If she was denied the opportunity, then we need to know how long she was denied that opportunity to determine if the length of the detention might have been unreasonably extended. But what if these employees weren't detained by police, but were instructed by an employer to stand behind the vans as a function of their job? Well, if that were the case, I suspect they wouldn't have to answer questions and would be free to leave without criminal consequences, but leaving might jeopardize their employment at the discretion of their employer, not law enforcement. Arizona is an at-will employment state, after all, and if an employer wants you to be in a place and not have your phone on you during hours of employment, well, that's not exactly unusual. So we absolutely need to determine if this was a function of a job or if it was a detention by law enforcement. I'm not trying to defend ICE or illegal immigration. I'm just trying to make sense of some very strange reports. There's a lot of information that just doesn't make sense, and when something doesn't make sense, it usually means there isn't enough information. Is ICE being directed to violate the Constitution? Have ICE agents in Arizona gone rogue? Are the reports untrue or lacking sufficient information? Am I just wrong about this whole thing? At this moment in time, it's hard to say. But this is being investigated, and I'm looking forward to more information coming to light. In the meantime, it might be a good idea to carry identifying documents with you, even if you're not actually required to, and to make sure you get clarification as to whether or not you are detained and who is conducting the detention. If a warrant is presented, make sure it has been signed by a judge, but understand a warrant may not need to be presented. Let me know if you've had any experiences like this with ICE in the comments. Like and subscribe for more legal breakdowns, and until the next time, be good, stay safe.